Good morning, friends. This is your RAPETI Suryanarayana advocate from Vizag. In the earlier sessions, I gave many lectures with regard to various topics. All the topics are useful for common public and to the law students, practicing advocates, and also to the students or persons who are appearing for judicial, competitive exams and other competitive exams. In the previous session, I gave lecture with regard to information in cognizable case and also information in non-cognizable case, and also about investigation in both cognizable and non-cognizable cases or offences. In this case or session, I would like to give lecture some more important points with regard to this first information report and investigation on that first information report. This is part 3 with regard to first information report and investigation on that information report. This is very important topic to the general public. All the topics are useful to both lawmen and laymen also. In the previous session, I said that if the information given by the informant or suffered person or complainant, if discloses commission of cognizable offense, then the police officer have power to investigate the offense without order from the magistrate. Why? Because that information discloses commission of cognizable offense. The police officer have a power to investigate the offense. If the information which is given by the victim or suffered person or the complainant discloses commission of non-cognizable offense, then the police officer have no power to investigate such non-cognizable offense without order from the magistrate. Without order from the magistrate, the police officer have no power to investigate the offense. Why? Because that offense is a non-cognizable offense. Okay. Then let us see what the next step will goes. If from information received or otherwise, if information received or otherwise by the police officer, that means the information is received by way of complaint or some other to the police officer, then the officer in charge of police station have reason to suspect the commission of an offense. The commission of offense. From that information or basing on that information received by the police officer, the police officer has reason to suspect the commission of an offense. If the commission of an offense is a cognizable offense, then the police officer is empowered to make an investigation with regard to such an offense. then the police officer is empowered to make an investigation with regard to commission of an offence. Then the police officer will make a report to the magistrate, who is competent to take cognizance with regard to such offence on the police report, and this police officer shall proceed to the spot to investigate. Shall proceed to the spot to investigate. Or this police officer shall depute any of his subordinate police officer to proceed to the spot to investigate such offence or case. I hope it is clear. If information received by a police officer or officer in charge of police station, and such police officer or officer in charge of police station has reason to suspect the commission of offence, that is cognizable offence, then the police officer have a power to investigate such offence. Then what the police have to do? The police officer or officer in charge of police station shall report with regard to such information and reason to suspect to commission of such offence to the magistrate, who is competent to take cognizance of such offence on the police report, and the police officer shall proceed to the spot to investigate the offence. Or this police officer shall depute his subordinate to proceed to the spot to investigate the offence. Later, this officer in charge of police station, that is police officer, or his subordinate, will investigate or shall investigate the facts and circumstances of the case, and if necessary take measures for the discovery and arrest of the offender of that offence. I hope it is clear to all. If the police officer receives information and they have a reason, police officer have a reason to suspect the commission of offence, and the police officer given a report to the magistrate, and also this police officer proceed to the spot to investigate, and investigate the facts and circumstances of the case, and also if necessary take measures to discover and arrest the offender by the police officer. Arrest the offender. Why? Because this is a cognizable case. The police officer have a power to arrest the offender. This is a very important point. This is a case related to the commission of cognizable offence. So, the police officer have a power to investigate and arrest the offender. If the case is a non-cognizable case, the police officer have no power to arrest the offender without warrant from the magistrate. That means, in case of non-cognizable offence, the police officer have no power to investigate the offence. Why? Because it is a non-cognizable offence. Then how he have to investigate that non-cognizable offence? He have to get the order from the magistrate, who is competent to take or try such offence, or competent to commit such offence for trial. That means the police officer have the power to investigate a non-cognizable offence only with the order from the magistrate, only for the purpose of investigation. The magistrate will give order to the police officer to investigate the case. That is a non-cognizable case. Here the important point is, these police officers have no power to arrest without a warrant the offender. Why? Because the offence is a non-cognizable offence. Only the police officer have a power to investigate the offence or case with the order from the magistrate. Without order from the magistrate, the police have no power to investigate a non-cognizable offence. This order given by the magistrate to the police officer in non-cognizable offence is only for the purpose of investigation in a non-cognizable offence or case, but not to arrest offender. Why? Because this is a non-cognizable case. That means the police officer have no power to arrest without a warrant from the magistrate. The police officer have no power to arrest any person without warrant from the magistrate in case of non-cognizable cases or offences. Only the police officer have a power to investigate in non-cognizable offences with the order from the magistrate. Without order from the magistrate, no police officer have a power to investigate a non-cognizable offences. Whereas in case of cognizable offences, the police officer have a power to investigate a cognizable offences and also have a power to arrest an offender in cognizable offences. Whereas in case of cognizable offences, the police officer have a power to investigate the offence, cognizable offence, without order from magistrate, and also the police officer have a power to arrest an offender without warrant from a magistrate. I hope it is clear. In case of cognizable offences, the police officer have a power to arrest an offender without warrant from the magistrate, and also the police officer have a power to investigate a cognizable case without order from the magistrate. Whereas in case of non-cognizable offences, the police officer have no power to investigate non-cognizable offence without order from the magistrate. In the similar way, the police officer have no power to arrest without warrant from the magistrate in case of non-cognizable offences. I hope it is clear to all. Okay, next. The police officer proceed to spot and investigate the facts and circumstances of the case, and if necessary, take measures to discover and arrest the offender. This is in cognizable cases. Here, if the information received by the police officer, such information discloses that the offense committed by a person and the name of the person is also stated in the complaint or information, and that offense is not serious in nature, then what the police officer will do? Where the information discloses offense committed by some person, that name of the person is also stated, and that offense is not serious in nature, then what the police officer will do? Where the information received against any person by name, where the information received with regard to the commission of offense against any person by name, and that offense is not serious in nature, then the police officer shall not proceed to the spot to make an investigation, or shall not depute his subordinate officer to proceed to make an investigation on the spot. Why? Because the offense is not serious in nature, and also is against a person by name. Here the name is also stated, and the offense is not serious in nature. This information discloses, which is received by the police officer, not serious in nature. That means the offense is not serious in nature. So the police officer shall not proceed to make an investigation on the spot, or depute his subordinate to proceed to the spot to make an investigation. And because it is not so serious in nature, so need not proceed to spot and make an investigation to the police officer. The simple reason is the offense is not serious in nature. Next one. If the information received by police officer appears, if the information received by the police officer appears that there is no sufficient ground, for entering on an investigation. There is an information received by the police officer, and that information appears that there is no sufficient ground. In that information there is no sufficient ground for entering on investigation with regard to such information or complaint. Why? Because there is no sufficient ground to investigate that information or that offense. In that circumstances, the police officer will not investigate that case or offense. Why? Because there is no sufficient ground for investigation. If there is a sufficient ground for investigation, the police officer shall make an investigation. If there is no sufficient ground to make an investigation, to enter on an investigation by the police officer, then the police officer will make an investigation if there is a sufficient ground in the information received by the police officer. I hope it is clear to all. These two are very important points. If the information received by the police officer and in that information or in that complaint, the offense is serious in nature, then the police officer shall proceed to the spot and make an investigation, or such officer in charge of police station shall depute his subordinate to proceed to the spot and to make an investigation with regard to such an offense. If information received by police officer is not serious in nature, the police officer shall not proceed to the spot and make an investigation, or shall not depute his subordinate police officer to proceed to the spot and make an investigation. In the similar way, if the information received by the police officer appears or discloses no sufficient ground to make an investigation, then the police officer will not make investigation into that offense. Why? Because there is no sufficient ground. Then the police officer shall record his reasons for not making investigation in a report and submit to the magistrate. The police officer shall mention in his report with regard to the offense that is not serious in nature, due to which the police officer not proceed to the spot and make an investigation. In the similar way, if the information discloses or appears having no sufficient ground to make an investigation, then the police officer, due to that reason, that is no sufficient ground for making investigation, not investigate that case or offense. A police officer shall mention the reasons for not investigation with regard to the offense in a report and submit that report to the magistrate. In the similar way, the police officer shall also intimate or inform to the complainant with regard to the investigation whether he investigate the case or not investigate the case, shall be informed to the informant. This is about with regard to the information and investigation by police officer in cognizable and non-cognizable offences. This is very important topic to the lawman and layman and also to the competitive exams persons. Kindly like my videos and subscribe my channel and share my videos. Once again, I would like to give important point to you all. Only one important point in this, that is nothing but in non-cognizable offences, the police officer have no power to investigate an offence. Only with the order from the magistrate, the police officer have a power to investigate non-cognizable offence. And the police officer have no power to arrest any person without warrant from the magistrate in non-cognizable offences. Whereas in cognizable offences, the police officer have a power to investigate the offence without order from the magistrate, and also the police officer have a power to arrest any person in cognizable offences without warrant from the magistrate. This is very important point. I hope it is clear to all. So thank you a lot. Kindly like my videos, share my videos, subscribe my channel. Thanks a lot. Thank you.